want to talk about discipline procedures under the IDEA. So this is a real important area of the law, I think, in terms of protecting the child with special needs. Historically, it was found that children with special needs were getting suspended and expelled, at a much, much higher rate than their non-disabled peers. So Congress put in effect this protection for children with special needs, such that they couldn't be punished because of their disability. And here's how the law works. It says the removal of a child with special needs from school for more than 10 school days in a year constitutes a change in placement under special education laws. So we'll talk about what that triggers here in a minute. But if you think about 10 school days, at that 11th school day, a manifestation determination meeting, which I'll talk about in a second, is triggered. A procedural protection is triggered. Up to that 11th day, they can suspend just like they suspend a general education student, but not after the 10th day. Does it have to be consecutive days? Not necessarily. It has to be within a school year, but maybe it's at the beginning of the semester and maybe it's at the end of the semester. As long as the conduct is similar, it could be 5 days here and 5 days here, and then we have the manifestation triggered. Typically it's consecutive days, but it doesn't have to be. So after that 10th day, what happens? Well, it triggers this protection called the manifestation determination meeting. And the purpose of this meeting is to consider whether the child's behavior was a manifestation or caused by his or her disability. I mean, if it was caused by the disability, the law says, we don't really want to punish a student for that. That's part of their disability. Yeah, maybe we need to do something different. Maybe we have to reevaluate the student or consider a different placement or consider different supports. But it all has to be within the special ed purview of helping the child, as opposed to disciplining through expulsion or suspensions, because it's part of their disability. So here's what the law says. So within 10 school days of a decision to change placement due to a code of conduct violation, the IEP team shall review all relevant information in the student's file, including the IEP, teacher observations, relevant parent information to determine, number one, if the conduct was caused by or had a direct and substantial relationship to the disability, and number two, if the conduct was directly caused by a failure to implement the IEP. So first of all, you have to review all relevant information in the student's file, including the IEP. I had a case once where a student had a learning disability on his IEP. And he was known to have ADHD. It wasn't a disability category, but it was all through his IEP from going back years and years that he had ADHD and he was impulsive. So he committed an impulsive act, and what we argued was an impulsive act. The school district automatically said, no, it's not a manifestation because he has a learning disability. What in the world does this act have to do with his disability? It was transferring contraband from one student to another. So they looked at just his disability category and said, no, there's no relationship. But we dug deeper and found that, ADHD was a substantial part of his disability. And the school just overlooked that. And so we were able to show that had they looked at all of the relevant information, they would have seen that. Then they would have asked themselves, was this conduct impulsive or not? Which we argued it was, and a judge found that it was actually impulsive behavior.
Sign up for our newsletter at iepsolution.com for more upcoming IEP Tips to Equip webinars, live workshops, and boot camps that will go into this topic and other topics in special education in much more detail. Thank you for watching. this IEP Tips to Equip webinar.